I am opposed to same-sex marriage. I supported Prop 22, but I live in a society of laws, and I will, as I swore an oath to do, uphold the law. The difficulty is, what is the law? And I think that law is in flux. It is in the process of evolving as we see it, and I think it may evolve again in November. I have many years of experience as a CPA helping people solve and resolve property settlements, estate issues, custody issues, many issues like that. This issue is very, very much compounded. The problems are compounded with the nature of how this is being allowed, not allowed, being allowed, and potentially again now not being allowed. So I think it is incumbent upon us to consider that that law is still in flux. 80% of the people in our community voted in favor of Prop 22. I don't know what will happen in November in our community, but it is worthwhile, I believe, to consider this ordinance that was presented this morning. So, Mr. Barman, I'm going to give you a copy of it. I'd like you to review it for us. I'd like you to give us your legal opinion about, as I said, we must follow the law. I'd like you to give us your legal opinion about its validity, if it will stand up, you know, what aspects of it would work, what aspects of it, or if there are any that would be troublesome. I think I'll suffice it to say, while it's not popular in some circles, and it is popular in others, the first question I asked was, what is our legal responsibility? And I believe that the clerk is fulfilling her legal responsibility by issuing the licenses. It is within her discretion to perform marriage ceremonies. And if I don't like the decision that the DA makes within his discretion to indict or not indict an individual, I don't think it's appropriate for me to move around the district attorney and find another way to bring an indictment to someone. He's elected to represent the people and make that discretionary decision. Likewise, if our county assessor were to assess property or decide not to assess someone's property, it is his discretion to make that decision as elected by a representative of the people. I don't believe it's my role to step around him and find another way to do his job for him. If there's an issue between the electorate and those who are elected, that's where it should be settled.
The will of the people, if that was the only basis of our constitutional rights, all I have to look at, I saw an email day before yesterday saying, you don't have a duty to pay taxes. If we took a vote today, the will of the people would be we don't have to pay taxes. We could go back to voting rights. We could even go to the death penalty because there's a part of the Constitution that talks about cruel and unusual and so forth. But the will of the people is to elect officials and legislature, and here in California we're blessed because the people can also enact laws or constitutional amendments. The beginning of the introduction today, the chairman or vice chair said this is the time for members of the public to address our board that's not on our agenda but under our jurisdiction. The matter before us today is not under our jurisdiction, as Mr. Barman so noted. The decision as to whether or not to perform the wedding ceremonies rest with the clerk as provided by law. And the law does require the clerk to issue the license, but the law does not mandate the performance of the ceremony. I want to shift gears just for a moment to talk a little bit about my belief with respect to constitutional issues. Constitutional rights are not based on popular vote. They're embodied in our Constitution. And there is a system of checks and balances. And there are a lot of people, myself included on many times, that believe that the courts have stepped beyond judicial review and are actually engaged in, through their decisions, the net effect of making laws. I think that's probably, you hear it oftentimes as to whether a judge is a constructionist or not. And that's a huge debate within our society. But clearly, whether you're talking about at the federal level or at the state level, The courts, in a long, long history, they are the final arbitrator of what the Constitution means. That's it. The Constitution is not left to merely private interpretation, or we would have anarchy, because some people would say, I don't want to pay taxes. And when the courts then are not making laws, they're interpreting whether the law is consistent with the constitutional requirements. And do I believe that there's an over-activist judiciary? Yes, I do. Like Supervisor Maggard, I didn't vote for Proposition 22, and it was a law enacted by the people. And the Supreme Court of California, therefore, had the duty and the responsibility and the authority to compare that law against the state's constitution. So that's kind of the framework from where I come from. Prop 22 became law by the will of the people, not by the will of our elected legislators. Thankfully, we have that ability in California. Sometimes we can make laws and constitutional amendments so often that it works to our disadvantage as well. The California Supreme Court ruled that the voter-initiated law was unconstitutional. There will be a ballot measure in November, this time not as a law, but as a constitutional amendment, in order to help clarify what the Constitution really means for the Supreme Court's benefit. Because there's a lot of people that don't believe that they got it right in this case, myself included, but I acknowledge that. The law does not require that marriage ceremonies be performed by the clerk. Had the legislature intended for this to be mandatory, they could have simply stated so. I have to conclude, therefore, that the legislature, in enacting the law, intended for this decision to be discretionary, and it rests with the elected official having jurisdiction over that matter. Ms. Barnett has made a decision permitted by law. Her reasons or her motives are certainly subject to question, but this board has no jurisdiction over those reasons for her decision, with possibly one exception, and I would defer to Mr. Barman on this. If Mr. Barman had the factual basis to issue a legal opinion that he believed, in fact, that Ms. Barnett's decision was unlawful, I'm sure he would have issued such an opinion to us and to her. There's always risk in any decision you make, and lawyers make a good living off of arguing and going back and forth over those risks. I've seen no such opinion by county council. Ms. Barnett's decision and questions as to her motives must therefore be judged by the voters who elected her, or in a courtroom if there's a sufficient evidence that would indicate that her decision is unlawful or she had a discriminatory intent violative of the law or some civil rights. We can't decide that matter here. Ms. Barnett exercised her authority under the law just as the Supreme Court exercised their authority under the law. If she erred in her judgment, I'm sure there will be a lot of legal challenges, probably none of which will be resolved by the November ballot time. And the only people that are going to win out of much of this is probably the folks that make a living out of arguing law. I believe that this is going to unfold in the courts, and I do not. I know there's a draft ordinance here, but because of all of the legal principles that I've kind of laid out, insofar as the court at this point in time has said this right exists, for us to enact a local ordinance violative of what the Supreme Court has said doesn't seem to withstand scrutiny, but I'll defer that to Mr. Barman when he comes back to us at a later date.